I'm Karima Brown. It's Sunday morning and it's time for The Fix. Pravin Gordhan is not taking the Public Protector's report and findings lying down. He's taking the report on immediate review, saying it has no basis in fact and law. We hear from Gordhan's legal representative as well as freedom under law. Who's in and who's out as President Cyril Ramaphosa puts the final touches to his radically trimmed down cabinet. My expert panel and I will look at the drivers of his decision. And as is custom, we take a look at our weekend newspapers to see what's made headlines this week and why. The Fix starts now. This is The Fix, where every Sunday, without fear or favour, we question the big role players. We look ahead to tell you what matters, how it affects you, and why you should care.
Minister Gordhan was not authorized by Section 16(2) capital A of the PSA to approve Mr. Pillay's early retirement request with full pension benefits, as this section does not confer any power on the minister to approve early retirement with full pension benefits. Mr. Pillay was not entitled to an early retirement with full pension benefits under Section 16(2) of the PSA Act, the Public Service Act, because the section makes no provision for such full retirement benefits.
That's, of course, a Public Protector, Busisiwe Mkhwebane. Now, Pravin Gordhan will be heading to court to challenge the Public Protector's findings that he had acted irregularly when he approved the early retirement with full benefits of Ivan Pillay, the SARS former Deputy Commissioner. Advocate Busisiwe Mkhwebane released a report early on Friday directing President Cyril Ramaphosa to take disciplinary action against Gordhan and for SARS to recover the money that was paid as an actuarial shortfall on Pillay's behalf. Joining me now in the studio for more on this is Gordhan's next move, and his legal team is here to talk to me, Mr. Tebogo Malatji. Thank you so very much for joining me here on The Fix. You are Mr. Gordhan's lawyer. And then joining me also is Nicole Fritz. She is the CEO at Freedom Under Law. They have also weighed in on the matter. Nicole, thank you so much. Good morning, and thank you for coming to The Fix.
Good morning, Karima. Thanks for having me.
Now, of course, we've had a very heavy day yesterday, the inauguration of the president, a lot of hope, a lot of anticipation. And in one of the correspondence, there's actually a reference to the fact that the Public Protector's findings on Friday was an attempt to put a blight on what is supposed to usher in a new dawn. In fact, Nicole Fritz, you put out a statement. You said, Freedom Under Law is dismayed but not surprised to learn that the Public Protector's finding in respect of Mr. Ivan Pillay's early retirement and Minister Pravin Gordhan's authorization of the retirement. The matters canvassed in the Public Protector's report are the exact same as those which frame one of the most notorious episodes in the National Prosecuting Authority's history, the decision to charge and then ultimately ignominiously withdraw charges against Gordhan, Pillay and former SARS Commissioner Oupa Magashule. Now, FUL has been at the forefront of fighting this battle for a very, very long time. What do you make of the Public Protector's argument that the PSA law does in fact not grant Mr. Gordhan the right to have granted Mr. Pillay that early retirement?
Well, I think she's incorrect in her findings, but I think it's, her report, her investigation is bedeviled by far more than a kind of incorrect reliance on a particular provision. When the law looked at, and I think it's an entirety, actually does prevent that, and we know that there have been several instances in which this has occurred. We know that Minister Gordhan, in making his decision to authorize, did not do so in any haste. He received several legal advices, none of which put to him that he was prevented or prohibited from making such authorization, suggesting that it was entirely lawful. But I think what reading that report, what sort of jumps out at one is this idea that she comes to these findings. She releases this report on Friday, less than 2 days after she has in fact received the submissions from the implicated parties. There is no opportunity, she has had no opportunity to meaningfully engage with those responses. It is in no way consistent with the most basic tenets of procedural fairness that she would have rushed to make this announcement on the Friday morning, given the limited time that she's actually had the opportunity to engage with these findings. And so one has to ask, why the haste? Why this undue haste on her part? What is she attempting to achieve by rushing to make this pronouncement on the Friday morning when she has not engaged fully with the submissions of the implicated parties?
Mr. Malatji, you represent Mr. Gordhan. He's one of the implicated parties. What do you make of the haste of the public protector? Does she have a motive other than being a break on power and being a watchdog, actually a constitutional watchdog, on those who abuse power?
Well, I must pick up on what Nicole has said. What is obviously troubled us is the fact that complex as the matter is, and with the best of legal brains, it couldn't possibly have been processed, all the submissions, in 2 days. So the haste is a matter of concern to us, and it brings to question whether due process has been followed. Due process means that you've got a reasonable expectation that the decision maker, in this case the public protector, will engage meaningfully with submissions made, and then only then come to a decision. Less than 48 hours is, to our mind, hasty. And secondly, of course, the timing is just, for all intents and purposes, whether you look at it from a legal perspective, technical perspective, political perspective, the timing was just off. It's Friday before the minister announces before the president is inaugurated, and thereafter then will announce cabinet. So that's a matter of concern to the minister. But most importantly, let's not forget what this is about. Minister exercised what is a legislative discretion granted to him in terms of the Public Service Act. So it's done not by him, but by many other ministers. At every other occasion, there are thousands of these applications. They come through. He takes great caution at arriving at the decision, consults widely, and eventually comes to that decision. So when we measure his decision today, and as the public protector did, we must measure it on fact and law. What is the fact? The fact of the matter is, Mr. Pillay was 56, so he was entitled to retire. And matter of fact is, the debate became, does he retire with a penalty or not a penalty? And matter of law, I'm putting it as easily as it is, complex as the matter might be, but easily put, as a matter of law, a minister then gets asked, do you allow him between 55 and 60 to retire with full pension benefits or not? And then a number of considerations that relate to that, which minister consulted widely. In fact, if you look at our letter, it's consulted no less than 6 people over 3 months, to come to a decision. And we say she's got it wrong as a matter of fact and law, but we've made those submissions, and we don't think in a matter of 2 days she really had regard to those.
Now, Nicole, you saying that you are not surprised by the public protector's behavior, and I'm not sure why you say that. I'm going to ask you in a moment, but allow me to just quote from the judgment in which the public protector was severely taken to task over the Estina dairy matter. The judge, Ronald Tolme, says, when the public protector fails to discharge her mandate and duties, the strength of South Africa's constitutional democracy is inevitably compromised, and the public is left without the assistance of their constitutionally created guardian. It means that a vital constitutional check against the abuse of power is lost. And that is Judge Ronald Tolme in the North Gauteng High Court, setting aside the public protector's report into the Estina dairy matter on the 20th of May 2019. Now, that is not very long ago. It's in our very recent history. There's another judge, Cynthia Pretorius, in the North Gauteng High Court, who said, in the matter before us, it transpired that the public protector does not fully understand her constitutional duty to be impartial and to perform her functions without fear, favor, or prejudice. And that's Judge Cynthia Pretorius in the North Gauteng High Court, setting aside the public protector's report into the ABSA Barclays, or rather ABSA Bancorp, South African Reserve Bank matter, which was the 16th of February 2018. So the public protector has two cases that have already been reversed in law in terms of a court. And in the last case, of course, she capitulated in court. She admitted she didn't really have an argument. Do we have a public protector that actually understands what her role is? And more importantly, her understanding of the law, because Mr. Malatji's just quoted the same piece of legislation that the public protector has used to say that her conclusion is that the minister acted unlawfully.
I think that those two judgments, which contain really scathing criticism of the public protector, must leave the public in doubt as to whether the public protector fully understands not only the provisions of the law with which she is engaging, but the gravity and the importance of her office. And I think, there's been suggestion that the report, the public protector's report of Friday, will be taken to court, that a review will be sought. What courts don't do, but what is important for the public to bear in mind, is look necessarily at the discrepancy in the way in which an office holder is wielding their powers. And I think if you compare the public protector's findings in the Estina Dairy case with the report that was delivered on Friday, the public has to be left bewildered. So the court, it was a judgment which came out Monday, says she has failed to do the most kind of cursory investigation. She can't suggest that resource constraints prevent her from examining the true beneficiaries of the Estina Dairy scheme when she had the telephone numbers and the names of these beneficiaries. It makes the finding, it says that the public protector, she unjustifiably narrows the scope. So she doesn't look at the involvement of the Premier, of the MEC, of these key sort of office holders in the Free State in order to make these findings, which the public, I'm sure, discordant with what the public knows to have happened in the Estina Dairy scheme because of investigative journalism. And the court says she has failed to have an open and an inquiring mind. She has failed to assure the public that she is about discovering the truth, or even an attempt at discovering the truth. And you hold up that scathing judgment against Friday's report, and you have to think, this is a public protector that is doing the same thing yet again. And I think that is tremendously concerning for the public, that an office bearer invested with such enormous powers under our Constitution should not be enforcing those powers, wielding those powers with an understanding of the gravity of the weight of those powers.
In fact, when referring to the Estina Dairy case, Mr. Malatji, it says the Estina Dairy matter is one of the most brazen and flagrant examples of state capture under the destructive government of the ANC's President Jacob Zuma, with Magashule as Free State Premier. Millions of rands were channeled to unviable projects, with many of those millions spirited off to the Guptas. And what is really interesting here is the fact that the public protector actually altered her predecessor, Thuli Madonsela's findings. She altered the findings and ignored the rest. She decided not to interview anyone of importance. She refused to requisition proper financial statements and opted out any references to Magashule, the implicated premier, and remarkably she left it to Magashule, an implicated party, to determine how the investigative journalist processes needs to happen. Now, if one compares her leniency with, let's say, in allowing Mr. Magashule, who is patently involved in the case as a matter of fact and not speculation, and she didn't allow your client 48 hours to actually study his representation, what is the conclusion that you are coming to, apart from the fact that you are obviously going to go and seek an urgent review?
Yes, I'm obviously limited in my response in what Minister will be advised in terms of formulation of his review application in the question you've put to me. But to our mind, there's a number of factors that one needs to consider. Firstly, and we keep on making this point, this is not a new matter. In 2014, SARS itself, then under Commissioner Tom Moyani, thought that this transaction, which is the retirement of Mr. Pillay, was unlawful. It sought legal opinion. That legal opinion said there was nothing wrong with the process. Process being from recommendation by Mr. Magashule, then Commissioner, to Minister's approval. That opinion is a matter of formal record. And then you have the processes in 2016 where the NPA prosecuted Minister and preferred charges against him, and those charges were withdrawn. And then you have the Nugent Commission, which makes a pronouncement on the matter. But forget all of that. You know, the public protector is required to investigate matters which are not older than 2 years. When she does, she must have special circumstances. To this day, we're waiting to hear what those special circumstances are relating to this particular matter. You know, so it's particular attention by the office of the public protector is a matter of concern to Minister.
Absolutely.
One would have thought, you know, it should have been a matter of so many investigative processes.
I'm told to wrap, but Nicole, I need to ask you this question. You said that you were not surprised by the public protector's decision. Is that surprise informed by your opinion that suggests that she has a private score to settle with Minister Pravin Gordhan? Is she seeking to influence who Cyril Ramaphosa appoints to his cabinet?
I mean, we're certainly not privy to any information which would suggest that there's a private score to settle, but we have seen several attempts to target Minister Gordhan. We know that the enterprise of state capture is not only about clothing certain public officials with impunity, allowing them to kind of milk the coffers of the state for self-interest, obviously with the connivance of certain, private parties. But it has also been about targeting individuals who and institutions that hold out the prospect of accountability, that threaten the impunity. And I think Minister Gordhan, in several offices, has acted as a bulwark, as some form of protection, proffers accountability. And it is certainly in the interest of certain powerful political parties in this country that he be neutralized, that he not be able to occupy political power, that he not hold out this threat of accountability. And we saw that certainly in the attempt to charge Minister Gordhan by the National Prosecuting Authority with the connivance of the Hawks. And as we said in our statement, that was one of the most infamous episodes in the National Prosecuting Authority's history, where they had to climb down ultimately because there was not a shred of evidence supporting an attempt to charge them with criminal wrongdoing in respect of this episode. And we now have this attempt to reheat this long cold dish again in order to seemingly to impugn Minister Gordhan. Whether the public protector does that wittingly or it is just a matter of coincidence certainly the impugning of Minister Gordhan is in the interests of certain powerful political interests in this country.
All right, that is where we will have to leave it. Nicole Fritz from Freedom Under Law, and of course Mr. Malatji, who is the legal representative of Minister Gordhan. After the break, I'll be joined by an expert panel for a closer look at the drivers of Cyril Ramaphosa's decision when it comes to his much anticipated trimmed down cabinet, which is expected to be announced tomorrow.